Yes.
Good afternoon, everyone. Thank you for participating in Ready to Work Madison County Expungement Day. It's now 12 o'clock and we're going to go ahead and get started. Please be advised that this webinar will be recorded and it will be made available upon request. To join the audio, please call 1-855-297-9064. The conference ID is 9974004669. To preserve the quality of the audio, you've been placed on mute. We would also ask that at this time, if you would mute your phones if you're participating by phone. You may submit any questions, comments, or concerns using the chat feature. For technical assistance, please contact Latasha Barnes at lbarnes@lincolnlegal.org or 618-462-0029, extension 3022. At the end of the presentation, please return your completed evaluation to Latasha Barnes via email to receive a copy of your CLE certificate. Thank you again for your participation. Our speaker today will be Daniel Keener, the staff attorney with Land of Lincoln Legal Aid's Western Regional Office in Alton. He's worked with Land of Lincoln since October 2016 and is currently the attorney assigned to the Ready to Work program, which helps address legal barriers to employment, including expungement and sealing of criminal records. He also represents clients in housing and homeownership cases. He's a 2008 graduate of Washington University School of Law and is licensed to practice in Missouri and Illinois. Prior to working for Land of Lincoln, he was an in-house attorney for a labor union for 6 years. At this time, we'll now turn the presentation over to Daniel Keener.
Thank you, Tasha, and thank you, everybody, for joining us. And I hope you can hear me okay. I have got like a bit of a sore throat thing going on, but if I need to speak up, just put it in the comment box, and Tasha will pass that along to me. So thank you so much for joining. We're really excited about the Madison County Ready to Work Expungement Day that's coming up on September 27th, and we really couldn't do it without having volunteers to help us out. So basically, in terms of what the volunteers will be doing at the event, is we're hoping that you'll just basically have the already in advance reviewed all of the criminal records of all of the applicants there, and we'll have the petitions prepared, and what you'll be doing primarily is sort of walking the clients through the petitions and explaining what it means to them. So that's kind of what I'm going to focus on, but I'm also going to give just a general overview of expungement and sealing law in Illinois. So we'll just get started now. So our first part is what is Land of Lincoln Legal Aid? Most of you probably know because you either work here or you've volunteered here before, but basically we're a nonprofit, legal aid nonprofit helping low-income folks in central and downstate Illinois with all sorts of issues, including expungements and sealings, but also housing, public benefits, education, domestic violence. So we're a pretty great organization, and thank you for helping us out. All right, and so this is just a slide about why the work for expungement and sealing is important in particular. And so here you just see, so 1 in 3 Americans have been arrested by age 23, and so that results in a lot of folks who are applying for jobs or applying for school or whatever, applying for housing, being held back because of their criminal records. And it shows that clearly if folks can get a good job, it's really helpful, usually prevents folks from going further into crime. Basically, recidivism for folks with full-time employment is only 15.7%, where it's up to 47% for folks who don't have that employment. And that's just kind of a listing of just a variety of things that having a criminal record can hurt you. And so in addition to employment, there's housing, education, public benefits, parental rights, professional licensing, and also it can create some debt issues as well. And so, yeah, a lot of folks use background checks. 90% of employers use them in hiring. About 80% of landlords use them, and 60% of universities and colleges use them in admission. So that's just an example of some of the doors that can kind of be closed to folks if they have a criminal record, which is why trying to help them with expungement and sealing for stuff that's eligible is important. So this is the statute. This is the law in Illinois governing expunging and sealing of criminal records, and that's the Criminal Identification Act. And kind of always an important thing to point out, I think, to folks when we're helping them at events like the upcoming Expungement Day, is that it's always discretionary, never automatic for adult criminal records being expunged or sealed. We can always help folks file these petitions, but then there's always a chance for objections from the law enforcement agencies, and then ultimately it's up to the judge's discretion. But the cool thing is that the state legislature here in Illinois has been amending the act over the past, I'd say, 5 or so years, quite often to make it better, a little easier for folks who have records they need expunged or sealing. They've extended the number of types of felony convictions that are eligible for sealing. Outstanding fines and fees can no longer be a barrier to sealing, and if somebody has a judgment of restitution, rather than that being a barrier to sealing, it can be converted to civil judgment. So those are just a couple of the ways that the law has changed recently to try to make it easier for folks who have records. And then there's also the Illinois Human Rights Act that just kind of talks about some situations where employers are forbidden from using records even if it appears on a background check, if it's expunged and sealed or dismissed, it didn't result in a finding of guilty. So that's just another statutory remedy there. So now this is kind of, I think, also, again, one of the really important parts to know for events like the Expungement Day, is just to be able to explain to the clients just sort of what is the difference between expungement and sealing, both what does expungement mean versus what does sealing mean, and also then what's eligible for expungement and what's eligible for sealing. I think this needs to be really, the important thing to explain clearly to folks, just because we don't want them to be confused about, what could happen to their records and why is it eligible for the one process and not the other. So basically, there's expungement is available for non-convictions, and that involves either physically destroying the records or impounding them or returning them to the petitioner and eliminating the name from any sort of official index or public record. So it's basically gone and not really accessible to anybody, practically speaking. Sealing basically means the records still exist, but access to them is unavailable without a court order. So a sealed record still won't come up to the general public, but there are certain situations where it will be available to entities such as government employers and other places that might do some sort of fingerprint type background checks. So expungements are sort of completely gone, destroyed, or impounded. Sealing is hidden from public view, but is still available if there's a court order or in certain other situations. And this is just, again, kind of access to expunged records versus sealing. And yeah, that is I think is helpful because this one gives some examples for sealed felony convictions who, what type of employers might see those. So those include places like the school districts, fire departments, park districts, financial institutions, other state and local government institutions, and some private organizations that are kind of involved, like taking care of children. So again, sort of going along with like schools. So that's just, I think, important just to kind of know what's the difference between what does expungement and sealing mean and who could have access to those records even after the process is completed. Okay, so now we're moving on into what can be expunged. And so basically what can be expunged is the term we use is non-convictions, or what can be expunged, and to really figure out whether something is a non-conviction. What we look at is actually kind of the sentence. The outcome is what determines if something's a non-conviction. And so non-convictions include acquittals, dismissals, releases without charges, or nolle prosecutis, where the prosecution is dropped. So those are kind of the most common ones. I'd say the other most common ones would probably be number 3, which is order of supervision successfully completed. The other things that could be considered non-convictions for the sake of expungement is a conviction that was vacated or reversed. I don't see those a lot, but that's a situation where it could apply. And then there's also orders of qualified probation that are successfully completed. And there's actually on another slide just kind of a listing of what types of probations are qualified probations, and it's usually stuff that involves first offender drug offenses. And then if there's been a pardon conviction, a pardon from the governor, the prisoner review board, that's still, the pardon must actually say that it authorizes expungement in order for it to be able to be expunged. Let's see, and again, kind of going into what sentences kind of determine whether something's a conviction or a non-conviction. So there's sort of a list of what those qualified probations would be on the non-conviction side. And then on the conviction side, you have jail, prison, boot camp, probation, conditional discharge, time considered served, and fines as a standalone sentence. So, and that's just an important thing to keep in mind, because sometimes people think like, well, I didn't have a sentence, I just paid fines. Well, if you just paid fines, that's actually considered a sentence and it's tied to a guilty conviction of the record. And so sometimes people think all types of probation might be considered a non-conviction. It's like, I had probation, I didn't go to jail. Well, actually under the statute, it's really just these really specific types of probations, which primarily help first-time drug offenders that are considered qualified probations. That completion is a non-conviction. Other types of probation, even if you complete it successfully, still considered a conviction. All right. And so then here's what can be expunged. So what the kind of the key inquiry in terms of whether something can be expunged or sealed is you need to know whether it's criminal in nature. So basically any felony convictions, except for a handful, which we'll discuss later, which are not eligible at all. But generally, felonies are considered criminal offenses that could be expunged or sealed. Misdemeanors, municipal ordinance violations. So the trick there is that misdemeanor ordinance violations, if they're considered criminal in nature, but criminal in nature is not defined in the statute. So that's really kind of a tough thing, because ordinance violations that show up in a criminal record can include things like, I think my personal favorite is animals running at large, which I guess somebody had their dog not on the leash and they got a ticket for that. And generally what we do is for ordinance violations is we'll just go ahead and petition for them if they're eligible, and basically kind of let it be up to the prosecutor, the state's attorney, to decide whether they want to object. Whether they want to object to something for not being criminal in nature. And then with regard to traffic offenses, they can only be expunged or sealed if they're Class A or B misdemeanor traffic offenses, which tend to be stuff like driving while the license is suspended or revoked. Because then we also see a lot of people have Class C or lower misdemeanor offenses on their traffic record. Especially you'll see a lot of either it's labeled as a Class P or a Class U, and those are petty cases or uninsured vehicle cases, and those cannot be expunged or sealed, even if they're dismissed, whatever. It's just I think that people have so many of them, kind of the idea is they're so common, we're not gonna, and they're not a big deal, so we're not gonna have them something that's eligible for expungement and sealing. And then there's also, I guess, I haven't really seen any of these, but apparently business offenses cannot be expunged. And then I guess there's also this list of petty offense. Again, I've never really seen a Class P petty misdemeanor outside of the driving context. So,
Daniel, we have a question.
Yeah, sure.
Does Madison County allow for expungement or sealing of Metrolink or bi-state ticket cases? It seems that they've been able to do those in St. Clair County, but more recently the county has been taking a more harder stance on it.
Yeah, so I've heard about that. I actually had a discussion with my colleague May, who works down in the East St. Louis office, about that just recently. So what I will say is I cannot recall ever seeing a Metro ticket violation up here in Madison County. Because I think Metrolink itself, where most of that comes from, does not actually go into Madison County. I think all the stops in Illinois or St. Clair. So I haven't seen them. If we do see them, I would still go ahead and file for that. Like other ordinance violations, I would say go ahead and file for them and see if we would get an objection from the state's attorney's office. But like I say, I haven't seen that pop up in Madison that I can recall. See. So here's stuff that cannot be expunged. So first off, there's civil cases. So sometimes civil cases will show up on a criminal record, especially if it's usually stuff that's family related. But civil cases, even if it's an order of protection, that's not something that can be expunged. Supervision for DUIs can't be expunged. Like I said, generally supervision successfully completed can be expunged, but not for DUIs. And I've actually talked about that with the Secretary of State's office, and it's kind of like they have a one strike policy sort of with DUI. So they, even if it's been a supervision, they need to know if you had, a DUI offense. That's why that cannot be expunged. Supervision for sex offenses against minors cannot be expunged. And then there's this weird reckless driving. Generally, supervision for reckless driving can't be expunged, but there's a youthful exception violation if it occurred under age 25, no other convictions for reckless driving or DUI, and now the offender is older than 25. That doesn't come up a whole lot, but it does occasionally. And then, of course, if it's resulted in a conviction, it cannot be expunged because that's what sealing is for. So here's when different types of offenses can be expunged. So if it's been a dismissal or an acquittal, release without charging, there's no waiting period for that. For those qualified probations, it must be 5 years since the completion of that, and there must be a clean drug test from the past 30 days attached with that request. Because like I said, those qualified probations primarily relate to first-time drug offenders. Then generally speaking, the requirement is 2 years since supervision if it was successfully completed. So let's see. So the one thing I'd point out here, so there's 5 years for a small number of situations, which I never see. So apparently domestic battery supervision used to be something that could get expunged. It isn't anymore. Criminal sex abuse not involving a minor. I haven't really seen that. And then insurance violations that are not petty offenses and scrap processors violating record-keeping requirements. I've never encountered that. But let me know if you do. It sounds fascinating. Let's see. So now let's move on to what can be sealed. And yes.
Hi, Daniel. We have a question. The question is, how should we handle marijuana possession under 30 grams next week? Is it correct that marijuana possession over 30 grams requires a petition to the governor to seal?
I do not know the part about whether possession over 30 grams requires a petition to the governor to seal or not. I know that there's, we've got the marijuana reform law going into effect next year, and that there are the convictions under 30 grams are going to be eligible for expungement kind of starting after January of next year. What we're doing now is we're basically going to be coding and filing the petitions for what they'd be eligible to do right now. So if it's something that can be expunged right now, we'll file for it to be expunged. If it's something that would need to be sealed right now, we'd file for it to be sealed. And then we're going to flag the ones that have the cannabis convictions. If right now it could only be filed for sealing, but then starting in January, be eligible for expungement. We'll file that as a sealing now. We'll flag it, just so flag that that's what it has, and then after January, then might get some sort of motion filing to amend it to be expunged rather than sealed. It's really tough to try to figure out what we want to do with that new law going into effect. And I don't know everything about that new law yet, but that's kind of the best idea we could come up with at this point. So hopefully that answers the question as best I can. So what can be sealed now is misdemeanor convictions unless specifically excluded, felony convictions unless specifically excluded, qualified probation and supervision when they're terminated unsuccessfully. And just the important thing to keep in mind, this is a really important one, is it's not the original charge that matters, but the final disposition of the case. So where that's important is sometimes you can see stuff that would not be eligible for expungement or sealing, but then the charge is actually amended or reduced to something that is eligible. Like an example would be you might have a domestic battery that is then amended or reduced to a regular battery. And also you can see something where it could originally be a felony, the original charge was a felony, but then the amended charge was a misdemeanor. And that's helpful because we put whether it's a felony or misdemeanor conviction on the petition, and maybe the state's attorney would be less likely to object if it's a misdemeanor conviction. And then there's one last thing. A person can have multiple felonies sealed at once, but if they've had sealing done, they cannot seal felonies that have happened after the sealing of a previous felony conviction. So I haven't encountered that situation yet, but it's definitely something I can foresee somebody trying to do. Unfortunately, the law does not allow for that. And so here's the stuff that cannot be sealed. So we've got domestic battery or violation of an order of protection, DUI or reckless driving except the youthful offender exception, sex crimes under Article 11 with the exceptions of prostitution or misdemeanor public indecency, battery of an unborn child, convictions under the Humane Care of Animals Act, and convictions requiring registration under the Sex Offender Registration Act, the Arsonist Registration Act, or the Violent Offender Against Youth Registration Act. So yeah, those are just the offenses that cannot be sealed. I will say so that as we're going through the reviewing folks' records in preparation for the event, we are kind of noting if something's not eligible, like right on the record. So we are trying to review this stuff in advance. So hopefully it's not, it's not stuff you'll have to have memorized and pointed out at that, and figure out for yourself at the event. But you might have to explain to somebody if they're like, well, wait, I had a DUI conviction. Why isn't that on? Because it's not eligible, unfortunately. So that's what cannot be sealed. And now this is when can it be sealed. So the waiting periods for sealing. And so the important thing to keep in mind about waiting periods for sealing is that they run from the termination of the last sentence for any conviction in any jurisdiction, whether or not the offense can be sealed. So the sentence runs like even if it's not a Madison County thing, but they just completed a sentence in another county, that would still have an impact on the waiting period. Or even if it's a sentence for domestic battery, which can't be sealed, they would have an impact on the waiting period. The waiting period is generally 3 years for felony or misdemeanor convictions. And I would say with the waiting periods, just like with the not eligible offenses, basically as we've been reviewing the records, as we've been getting them, we've been noticing folks with waiting periods, and we're going to try to help them separately. They're not help them at the second or at the expungement day event on the 27th. So basically, for the expungement day event at the 27th, we're trying to focus on folks who just have stuff that can be petition for expungement and sealing now, not stuff with waiting periods or not stuff with pending cases, which is not talked about in the slideshow, but it's something you see a lot is you'll get an objection from the state's attorney if you try to file for expungement or sealing while you have an open pending case. So for the petitions you'll be seeing at the expungement day event, they should all be folks who do not have waiting periods or pending cases. Let's see, that's just another, some more information about the waiting period. So one of the things it mentions here is so also, in addition to the qualified probation requiring the clean drug test within 30 days, that's also the case for when there's felony drug conviction. You'd also require a clean drug test to attach that's within 30 days of when the petition is being filed. And the great thing at this event, and we will be letting folks who need these know this in advance, is we actually do have somebody on site who will be conducting drug tests. So we can help folks with that. Unfortunately, it's not totally free. I think there's like a $45 charge for that, but we will be notifying folks who need those that they need them and that they can do it on site, but it's going to cost $45 in cash. So that's something we will be able to help folks with at the event. We're very excited that we got a partner to help us with that. And this is just a cool thing. I don't think it would really come up on expungement day, but the waiting period for sealing can be basically waived if the petitioner, while they were serving their last sentence, basically, if they earned some new level of education, whether that's a high school diploma, associate's degree, bachelor's, or other higher education degree, career certificate, or GED, then they can actually, if they've completed that while serving the last sentence, then they can waive the waiting period. The unfortunate thing is it has to be completed while serving the last sentence. Because I've encountered people who were while serving their sentence, enrolled in a 2 or 3 years master's program and then didn't complete it by the end of the sentence. So unfortunately, it didn't help them. But that's just a neat exception. I don't know if it'll really come up on the expungement day event.
Daniel?
Yes.
We have a question that pertains to slide 18. The question is, if an applicant had a felony but completed their 410 probation successfully, and I think they mean 710 or 1410 probation, successfully, and the case was dismissed, once that happened, would that then be an expungement, and would it require a drug test?
I guess what I think about the case then being dismissed is an interesting wrinkle. I mean, I would really want to check the actual court and disposition, like on Clericus, and see if it's actually saying, we have something in writing from the judge saying it's dismissed. I guess if the court actually changed it to a dismissal, we could petition it for expungement as a dismissal or acquittal, which would not require a drug test. But I would, like I said, I just want to be really careful about that, and we really check for that final disposition from the judge, because otherwise, unless if I see it really clearly, case changed to dismissal in the final disposition, I'd still be inclined to treat it as a qualified probation, which would require the longer waiting period and the drug test. So, but that's an interesting question. I think, it's always important if you're confused by record, and again, we're trying to do this because we're reviewing the records ahead of time, is if we're confused by a sentence, we'll actually go into Clericus, pull up the actual disposition, and try to figure out exactly what it means so that we're coding these as best as possible and not telling people to do either more or less than they need to. So it's a good, interesting question. I hope I answered as best I could. So then going back to this slide, something I talked about earlier, again, expungements and sealings are discretionary. Here's the factors that the court's supposed to consider if there ends up being an objection to expungement or sealing petition, and there's a hearing in front of a judge. These will kind of be the factors that the statute specifically mentions. It's basically just a standardized form whether an expungement or sealing is granted. So usually you don't necessarily know what the judge is, which one of these things the judge is basing his decision on. But these are sort of the factors spelled out by the statute. So let's see. And that's, I think, the key thing going back to that point would just be on expungement day, just always emphasize to folks that this is the beginning of the process. It doesn't guarantee that, doesn't mean that their stuff's been expunged or sealed that day. It's the beginning of a process. And the process in Madison County, I would say, generally takes 3 to 6 months because the state's attorneys and the law enforcement agencies have 60 days from when the petition is filed to object. If there's no objections, the judges usually sign off without a hearing. So that's where it'd be more on maybe the 3-month side. But then if there ends up being a hearing, that where it could be more on the 5 to 6 side. So this is basically just saying what's kind of we need to know in order to code to kind of figure out what a person is eligible for, if they're eligible for expungement and sealing. And yeah, so this is stuff that we've already basically, and that has everything else. We've already done is, so here at Atlanta Lincoln, we've been doing the analysis of the criminal records. We're letting folks know if they need drug tests, and we'll have, like I said, we'll have people on site to do the drug test. And then basically we're also preparing the paperwork. And it's really that paperwork that you'll be going over with the folks on expungement day. So now, and most of this, I said at the beginning, most of this wonderful presentation has been information from either Reading Green Legal Services or Sue Simone, and they put together, and it was wonderful. And now we're going to like the 9 pages of screenshots that are what I added to this. So my apologies in advance, but these are just sort of the documents you'll be dealing with at expungement day. So it's kind of important that you have a chance to see them. So this is first page of a criminal record, criminal history from Madison County. This is not one of our actual clients. It's just somebody random we selected just for the purpose of having a demonstration while training volunteers. And so you'll see on the right side, you'll see some things have EEDA next to them. We've got ES, and we've got SMC. And so basically what that means is the E stands for expungement, and then if the S is the first letter, that stands for sealing. And then the second letters basically say why that's eligible for expungement or sealing. For expungement, what you'll see is you'll see DA for dismissal or acquittal. You'll see S for supervision successfully completed. You may occasionally also see QP for qualified probation successfully completed. There are a few other codes. They're actually listed on the petition sheet itself, but I think we very rarely use them. And then for sealing, the letter after S will always be an MC or an FC, meaning either a misdemeanor conviction or a felony conviction. And then this sample does not have any of these. I don't think there's a second page for it, but nope. So it doesn't have any. But if somebody has something that's definitely not eligible, we will have, it'll be written along the right hand there. It'll be written out, not eligible. And that's, and something you might have some folks, if somebody has nothing that's eligible, we would have weeded them out and told them, sorry, look, we can't help you on expungement day. But if somebody has a lot of, well, there's several things eligible for expungement and sealing. But then if they also had a domestic battery conviction, which would not be eligible, we would still help them, and it would say in the record next to the domestic battery, not eligible. And so that's something you just need to be prepared about at the event if somebody says, hey, what about my domestic battery? What about my DUI? Let's say, unfortunately, under the law, that stuff's just not eligible. And then the other thing is you might have noticed on the left-hand side, under a lot of the offenses, you might see circles, and it's generally either a P or a U that's circled. And that's just an indication that those are petty traffic offenses. Because actually where those circles are in each of the charges is either a letter or a number basically saying what class of felony or misdemeanor the offense was. And if it's a traffic offense with a P or a U, that means that it is a petty traffic offense and is not eligible for expungement or sealing. So those are the records. Again, we're going to be coding these. This basically a completed sheet like this should be in the file for everyone. You helped. You do not have to worry about doing this yourself at the event. We're doing it in advance, but this will be in the file. So in case the client asks, "Hey, what about my other charge? Or why is this coded as an expungement rather than a sealing?" You have the record, and hopefully based on the record and based on this training. And also there's been, I think Tasha emailed you all a flow chart, a one-page flow chart that kind of goes through what's eligible for expungement and sealing and when. And so hopefully with those, with that information, you can kind of explain to the client why things are coded as they are. So I'm just going to take a brief sip of water here, and then we can go into the petition. All right. So this then here, this is the first page of the petition, which will be kind of the other thing that you'll be helping the clients with at the event. Again, we're preparing the petitions in advance. You don't need to worry about preparing the petitions, but you basically just want to walk it through with the client and kind of explain what everything means. And there's a couple of spaces for either check marks or X's. You want to make sure the right spaces are checked or X. And there's also some places where the client will need to sign. So the first check mark is if you are requesting if you're requesting expungement, you want to click yes there. And then this is kind of the listing of the offenses that they're requesting expungement for, and hope you can kind of see how it all puts the information from the record just into a different format. You see the date of the incident, the charge involved, the law enforcement agency that did the arrest, and the outcome of the case. And then if somebody has more than six cases to be expunged, then there's a little box here at the bottom which says, you click that and then it'll say, hey, there's an additional page to look out for. So that's what that box is about. Then basically this says loading. All right, we're back. So this basically says why, basically why the offense is eligible for expungement. So this basically says you're not convicted unless if it was reversed, so you got a pardon from the governor. We rarely see those, but that's what that first group of check boxes is for. Then this next one is if it was an arrest, but all the charges were dropped. And then the fifth is just another variation on that. It's an arrest for a traffic offense. And actually, sorry, not that the charges were dropped, but rather the charges weren't even filed to begin with. So that's what 4 and 5 are about. Then 6 is the one where if it's a dismissal or acquittal. For at least one case, I was charged, was later acquitted or released without being convicted. 7 there is for the folks with the qualified probation. And then 8 is for folks with supervision. And generally, we tend to check the B under the supervision because that's for cases, that's the usual timeline. It's been 2 years since the supervision was successfully completed. And then 9 here is basically saying you are not seeking to expunge anything that's not expungible. So that's why we also always want to check that one. 10 is if you qualify for that youthful offender exception to reckless driving, which again we don't see a lot. And then 11 is something about Cook County, so we can skip that. Then box 12 here is if you're requesting to seal the records, check yes or no. And some folks will only have expungements or only have sealings. They won't necessarily have both, but this sample fortunately did. Again, you can see there's the chart kind of putting all that information from the record in the form here. This is basically saying you're not seeking to seal charges related to those petty traffic offenses. and basically you're not asking to seal anything unless if it's eligible, and you're not asking anything that's happened, a felony conviction that's happened after a sealing of a prior felony conviction. Those aren't even check boxes because there's no exceptions. It's just, hey, you better be telling the truth about that. And then number 17 there is if it's a supervision and for some reason they need to do a sealing of it rather than an expungement, that's what box 17 is for. Otherwise, 18A is for misdemeanor convictions, B is for felony convictions, and then C, as you can see, is some very specific situations involving drug conviction. And so generally, for folks, it'll either be A or B that folks would be checking under 18. And then 19 is saying that they're not they don't have to be on any of those registries. Let's see, 20 is if they got a certificate of eligibility from the Prisoner Review Board, if they got some sort of pardon that doesn't usually come up. And 21 then would be if they can skip their waiting period because of completing a level of education. I'm not aware of anybody at the event who has that situation, but that's what that box 21 is for. And then 22 looks like that's also about the youthful offender exception to the reckless driving. Then basically there's a signature and date line, and we will have, it is not you, it will be the client, the applicant, who will be signing and dating that. There's also a space for date, which we for address, which we usually use the client's address for now. That's kind of actually on a request from the county clerk's office. So we file a notice of appearance if Land of Lincoln's representing them, and that's how they know our contact information. But the court clerk also wants to know the client's contact information, so that's why we usually put their stuff in that address area. And then there's just a couple other pages that also need to be submitted along with the petition. This is basically notifying the law enforcement agencies involved in the arrest. It notifies both the actual arresting agency, the state's attorney's office, and then also sort of like the local attorney, local prosecutor, or city attorney for the local units of government. It's usually in Madison County almost always the state's attorney who would actually object, but I will say I see a handful of cases where it'll be the city's attorney who objects. And so again, we'll fill this out for you, so you don't need to know who the city attorney is for Alton. I will look that up and fill that out for you. Again, you just want to make sure that the applicant, the client, signs that, dates it, and files it with all the rest. And in this, there's nothing that you or the client needs to do about it, but we always have the order granting and the order denying are all also part of the packet and can be filed at the same time as the petition. And I guess that just makes things a little easier for the judges and the clerk further down the road. And so, yeah, speaking of clerks and speaking of this paperwork, so then the great thing is that the court clerk's office will have some volunteers there as well. And so then basically after you've gone through all this with the client, then we can actually, this is where, hey, go over here, this is where the court clerk is, and you can get it filed that day. And we've also had the chief judge has issued an administrative order waiving fees for everybody who files that day, so they can get their stuff filed and get it without a filing fee, and they can take care of that all that day. And we're really grateful for the court clerk's office and to the chief judge's office for helping us out there. All right, and now we're back to Sue's much nicer presentation. Again, here's the filing. Yeah, so one thing I will put out that number one there mentions multiple counties with multiple requests. This is just a Madison County event, and we've been telling folks that as we've been doing intakes for them. I mean, as long as they're not still in a waiting period in another county, we can still file for them for stuff in Madison County, even if they have stuff in another county, but for the cases in another county, they would need to do another petition, and maybe one of our Land of Lincoln offices would be able to help them on that, depending where the county is and what the situation is. But this event, we're just filing Madison County petitions for folks. And again, so this is just the process, like I talked about. It goes to all the law enforcement agencies involved, 60 days for an objection, and then a court date set for 60 days has passed. If there is an objection, like I said, Madison County, one of the good things is if there's no objection, the state's attorney will actually send something into the court and to us saying, no objection to this petition, and then the judge will actually just sign off on those without a hearing, and that's really helpful and can move things really fast for folks who don't have, something that state's attorney finds bad in their record. So this is this is what happens in court. Again, this is obviously would be after the stuff on the expungement day itself, and Land of Lincoln will be helping these folks. If there's objections, we'll be helping them in court, which will probably be early next year. And we might want some of our volunteer attorneys might help out with that as well if you're interested. But the court is why this is here is basically just you can explain to the clients what the process is. It's not going to be happening on the 27th. So basically, technically under the statute, even if there isn't an objection, the judge has discretion whether or not to grant it. So fortunately, our Madison County judges have not, they've just signed off on them if there's no objection. And we've got a new judge overseeing that docket now, but I hope he'll still follow that practice. If there is an objection, then we have hearings over the basis of the objections, and then if the petition is granted, that an order is sent to the state police, the arresting agency, and the court clerks, and all those agencies have 60 days to comply with an order. So if it goes to hearing, or even if it doesn't go to hearing, even if it's just signed off by the judge, then basically after the order is entered granting it, then there's 60 days for it to be removed. In my experience, I would say the court clerks and the local arresting agencies can be really pretty efficient with that. Unfortunately, sometimes the Illinois State Police, sometimes it takes a little longer than the 60 days, and occasionally we will get calls from clients about that. So let's see. That just kind of explains what the exact process is with a record is expunged or sealed, what exactly happens at the different places, the court clerk or the state police or the arresting agency. And then this is just some other remedies. I don't think we'll really be discussing these with folks here, but for example, because again, we're trying to focus on folks who aren't in waiting periods, who don't have pending cases. But then there's just some other things I just point out to, for example, sometimes people have, you want to get a job in healthcare and they can't get something sealed, or it'll still show up with that particular employer. They could petition for a waiver that allows them to work in the healthcare field, even with the record they have. Also, another one that might come up is clemency, because that's kind of the only option for stuff that's not eligible for expungement and sealing, just period, is you could go to the governor and see if the governor or the person on review board wants to grant clemency for the person on that offense. And we're getting towards the end. Let's see, there's just some other resources. There's where the Illinois Supreme Court standardized forms are, so that's where you could go and see blank copies of those forms. I had the screenshots for Illinois Legal Aid Online also has information about expungement and sealing, as does the State Appellate Defender's Office. And then there's the Prison Review Board in case you want to know about the clemency process. And questions. So we got a few during the presentation, but we've got about 10 minutes left. So if anybody has any questions, now's the time. Does anybody in the room with me have any questions?
No.
I'm here with some of our paralegals who have a lot of experience working on these cases, so they don't have questions. Natasha, are we getting any questions?
No additional questions.
Okay, well, if anybody has an additional question, you can type it in now. Otherwise, I hope this was understandable and helpful, and I hope this gives you a good idea, not just about expungement and sealing law overall, but particularly what you guys will need to do when you're volunteering on the 27th, and hopefully how to answer folks' questions on the 27th. You're getting questions from the clients. But again, if you're getting questions, me and Tasha will be there, as will some people from the state's attorney's office. So there will be folks who do this as kind of a regular part of their practice there to answer any questions that might come up that you still can't figure out. So if nobody submitted any other questions, then I guess I'll just, thank you all very much and have a great afternoon. Thanks for volunteering. We're really grateful.